Payment has to do with just making sure there are appropriate payment clauses in there for the type of contract you're pursuing, whether it's cost reimbursement or fixed price. But you may also want to make sure as a subcontractor that it's clear that about when you get paid, as a subcontractor, when you get paid, whether it's when the prime gets paid by the government or if it's some other reason. Typically, going to bid and proposal calls, typically each company, each party to the teaming agreement is responsible for his or her own costs during the pre-proposal stage, the proposal development stage, and during the source selection. Now, unless otherwise agreed and placed in the teaming agreement, you're responsible for your own costs and won't be paid otherwise. As far as exclusivity, I talked a little bit about that later, but earlier rather, it should be stated precisely how much contract, or how much work rather, one of the parties will get. In an intellectual property, typically an intellectual property rights clause, it limits the data rights to the specific contract that you're pursuing. It restricts the information to only a need to know, and it prevents any other type of authorized distribution, prevents broader distribution. Limitation of liabilities, again, both companies, each company is responsible for their own actions and not held accountable if in fact the teaming arrangement is unsuccessful in reaching whatever objective is stated in there. In the disputes clause, you're looking for the type of, deciding on the type of language, you decided on where, you decided on the state. In case there is a dispute, the most common dispute resolutions are negotiation, facilitation, mediation, and hopefully not litigation, but that's one as well. Then in terminations, you're always permitted to exit the agreement, and you always want to have a clause in there for doing that. Typically terminations come about because there's a failure to agree, or there's a failure to perform, or there's a failure to obtain proper consent and approvals from the contracting officer. Termination is also permitted should one of the parties have a deteriorating financial condition, or if the parties mutually agree to separate, or if the agreement just expires. The bottom line about teaming agreements is that pre-screening and just really tight looking at what the details are critical for both parties. As President Reagan used to say, trust but verify. And speaking of trust, how many of you have read Stephen M. R. Covey's book, The Speed of Trust? Trust is indispensable to sustaining any type of relationship. Now, I'm talking about Stephen Covey, the son, not the father who wrote The 7 Habits of Highly Effective People and who recently died as a result of a bicycling accident near his home. Stephen Covey recently spoke this past April to the Oklahoma Business Ethics Consortium. And in his book, he makes the basic premise about trust, that it's not only a social dynamic, it's also an economic dynamic. And essentially what he says is that as trust goes down, the speed of execution also goes down. And where do you think costs go? They go up. As trusts go up, the speed of execution also goes up, and costs go down. The basic point there is that building a trust relationship is vital to having an effective teaming arrangement. Contract Management Magazine, which is a magazine put out by the National Contract Management Association, which I've been a part of almost, well, too many years I'll say here, I won't. But This table talks about the best practices and lessons learned from folks that have been involved in teaming agreements. And I'm only going to cover a couple of those. But just looking at lessons learned, number 6, it says that to understand that the enforceability of contractor teaming agreements may be difficult. A contract is a promise or a set of promises for the breach of which the law provides a remedy, or the performance of which the law in some way recognizes as a duty. Both contracts and teaming agreements are agreements. However, a contract is enforceable by law, whereas a teaming agreement may not necessarily be so. It depends on the particular situation. Number 3, which says prime contractors should view and present their teaming agreements as so-called agreements to agree. And what that means is that teaming agreements are interim or temporary agreements, and they look forward to a final agreement. And the final agreement is either a contract or a subcontract. But in commercial law, a pre-contract agreement, which is what a teaming agreement is not legally binding. So this is just as a quick caveat, just to understand just how much legal room you have in a teaming agreement. Not saying it's not totally legal enforceable, but it's not a contract. It's not a final agreement. This is a new term. In fact, if you look at this term just came out in the Federal Register in May 16 of this year. In fact, the Federal Register sought industry comment, which should have been passed in July. But this is a definition that if you're a small business and you're interested in teaming, you need to be aware of. It's fresh, as Bill Cosby used to say. Small business teaming arrangement is an arrangement where 2 or more small business concerns have formed a joint venture to act as a potential prime contractor. Or it's where a potential prime contractor agrees with 1 or more other small businesses to have them act as its subcontractor under a specified government contract. Now, if you look at the sheet, the handout that you have, you'll see a term on there which says contractor team arrangement. That's not proposed. That's been in the Federal Acquisition Regulation for a long time. And that's for all teaming. Primarily large businesses is what that was primarily written for. It goes way back to the ASPR and things before that, Armed Services Procurement Regulation. Yeah, I've been in this business a while. But I just want you to look at that for comparison. This is a takeoff of that definition. That definition is in Part 9. That's specifically for small businesses. Now, assuming that this definition is accepted into the regulation, then small businesses must express their small business teaming arrangement in a written agreement. And the written agreement must specifically state that it's a small business teaming arrangement or a small business agreement. And that agreement must address roles and responsibilities, how much work is being distributed. It must be very specific in that regard. And it must be submitted to the contracting officer at the time that the proposal is submitted as well. Small business teaming presents opportunities, but it also presents cautions. And one of these cautions is a concept called affiliation. Companies are affiliates of each other when one controls or has the power to control the other, or a third party controls or has the power to control both. Remember, I was telling you earlier when this VA examiner, he was looking to ascertain ownership and what? Control. That's why he came. It does not matter whether control is exercised so long as the power to control exists. And by the way, CFR there stands for Code of Federal Regulations. Code of Federal Regulations is an annual systematic arrangement of the general and permanent rules published in the Federal Register by government agencies. Now, I should hasten to add here that the government does not prevent you or prohibit you from having affiliates. But it's important to know that if you have an affiliate, that the affiliates, you heard Judy talk earlier about how size is computed, and I also have it there. If you look at my last definition of small business, you'll see the same thing. It's either the 3-year average of your sales revenue, or it's your employee count average over 12 months, if I remember correctly. Well, when you have an affiliate, then the affiliate's revenues or employee count is added to yours. Now, as long as when that's done, you still meet the small business standard for whatever the set-aside contract is, then it's no problem. But you need to be aware that that's one of the cautions, is the word I'll use, for affiliation. There are two types of affiliation. One's general, and the other one is ostensible subcontractor affiliation. General affiliation is typically a relationship that exists outside of the specific procurement. And generally, when the SBA finds general affiliation, it applies to all the procurements you have going forward. General affiliation typically is either shared ownership or shared management.